Dear friends, colleagues, legal professionals of Azerbaijan, foreign diplomats and representatives of international organizations. My name is Adil Abilov and I am Director of the International Cooperation Department of the Ministry of Justice of Azerbaijan. From the outset, I'd like to mention that my intervention will be in English, which is stipulated by the reason of addressing wider international community. Today, I would like to talk about some aspects of the decree on enhancing the judicial legal reform signed on the 3rd of April 2019 by the President of Azerbaijan, His Excellency Mr. Ilham Aliyev, who has always been attaching utmost importance to the greater development of the judiciary. In particular, I would like to touch the issue of establishment of specialized courts to deal with cases related to entrepreneurial activity, tax and customs payments, disputes arising out of the payment of compulsory state, social insurance fees, and other matters. So let's start. As you're probably aware, court specialization is commonly considered to be an important reform initiative to advance the development of a successful judicial system. Court specialization is thought useful to address broader development constraints such as the need for more effective access to contract enforcement, improvements in the investment climate, etc. Studies from the United States, France, Netherlands, Australia, and other countries have shown that specialization can be helpful in improving the processing of court cases that are more complex or require special expertise. A study conducted by the International Intellectual Property Institute catalogued specialist courts in 90 countries in Asia and Pacific region, Europe, Middle East and Africa, North and South America, and the Caribbean. Some argue that the main reason for this development is the increasing specialization of the law and growing complexity of topics. Others cite a range of benefits that specialization brings, such as more efficient processes and greater understanding of the law and the impact of the court's decision on the parties and the environment by judges. So, why specialize? Judicial specialization generally means that judges have specific knowledge of and expertise in a particular area of law. More specifically, it also means that certain types of cases are handled somewhat differently, possibly even separately from the rest. While specialization in this sense is a growing trend, it's not new, and there are many examples of judicial specialization all over the world and in all types of legal systems. Courts that handled particular criminal cases were described in ancient Rome, and courts specializing on maritime law in England reach back to the 14th century. In the US, reports of specialized courts date to at least the creation of Delaware Chancery Court in 1792. Other examples include labor courts created in 1806 in France, juvenile courts in Illinois in 1899, the establishment of a special labor court in Denmark in 1910, and the development of Sweden's water courts in 1918. There are strong arguments in favor of establishing these specialized courts. First of all, specialized courts can resolve questions of law more efficiently and more effectively. The judges in a specialized court are experts in this field. Secondly, specialized courts give decisions with better quality, leading to more predictability. Specialist courts also can devote more time to individual matters of the case without having to give priority to other cases, such as criminal cases. Specialist courts also tend to adopt an informal approach to procedural matters. They are therefore better equipped to adjust the procedure to individual aspects of a case. Specialist courts have a significantly higher percentage of settlements. The reason is probably because the specialist judge can give a better direction with more authority. Well, these are arguments of a traditional character. In today's world, with global economy and opportunities to invest in whichever country or economy, there has evolved a very important argument in favor of establishing special commercial or business courts. A business court can play an important role in the economic development of regions or countries. It can be used as a tool to attract companies, businesses, investors, and investments to a given jurisdiction or to prevent them from leaving. A prerequisite is that the specialist court gives added value to companies and investors. The development of IT case management system in specialized courts speeds up the handling of cases, helps managing the court's workload, and reduces the likelihood of corruption. From all the above mentioned, it can be concluded that the recent presidential decree is aimed at further deepening of judicial reforms in Azerbaijan and shall simplify access to justice and foster rendering better judicial services. Now, we at the Ministry of Justice are exploring best practices in this area which exist elsewhere in the world. Therefore, we are working together with our good partners from the European Union, the Council of Europe, and other international organizations. The Ministry of Justice has also signed MOUs with ministers from 33 states of Europe, Asia, Middle East, and Africa. We are going to use our contacts to study what our partners did in this area. Should they have best practices established, we would be working on adapting these very practices in Azerbaijan. To conclude, I would highly appreciate if any of you could provide us with comments, suggestions on the topic discussed. Thank you very much for your attention.